one of you what you think are the most important items practitioners should leave today's presentation with. And I'll start with you, Derek Vandenberg.
I think the most important takeaway that I would offer, simply from the litigator's point of view, is that unlike in the past, patent damages, and particularly reasonable royalty damages, are something that the lead trial lawyer needs to be engaged with early in the case, to be working with the experts, with the other lawyers on the team, with the client, to be coming up with a quantifiable damages theory that makes sense, so that by the time you get to trial, you've hopefully developed theories that will both convince the jury, but then also pass muster at the Federal Circuit.
Ashish Pradhan?
Thanks. So I would say that there is a fair amount of flexibility that the experts have in determining reasonable royalty damages. Obviously today we've been focused on apportionment of the rate versus base and issues like that. And as long as the economic analysis is sound, it could be done in a variety of ways. So definitely creativity should not be barred, as long as there's a level of precision there.
Dr. Sean Sheridan.
I would say I think it's critical for anyone approaching a damages case to be thinking about apportionment. That can even include your lost profit cases. That's not to say that your damages still can't be quite substantial. They can be, but it's just something that you will need to address and address with rigor. And there are, of course, examples of where apportionment of a royalty base is not required, but there are no examples of, in my opinion, of where apportionment is just simply not required for a reasonable royalty or for lost profits. I think it's clear at this point that the courts are expecting apportionment to be addressed.
And Dr. Russell Mangum III.
Thank you. I think patent damages experts are typically familiar with case law. They should stay up on that and know about some of these things we've been talking about today. They understand the methods. I think there is a tendency, and there can be great added value to being creative and coming up with ideas. But I think what we see from some of these courts are that they still want to see the work. They want to understand the steps that are taken. And I certainly think it can help that if you're going through a certain approach, whether it's a certain quantifiable method or whether it's a certain royalty base, if you can point to industry practices or maybe business or finance literature, the court likes to see the backup, right? Whether it's through all the detailed work, the steps, the literature support, the industry practices, it's safer to go down that road one way or the other.